Alexandria, Serra, and it's Lawyer Talk Thursday again. I'm kicking it here with Gaby D.
Hi, everyone.
And we're talking all things divorce, money, military, and getting you what you deserve.
To do divorces, you have to ask yourself, is this contested or is it uncontested? That can change the fact as far as how quickly you can get it done. So the first step for any divorce is filing the petition at your court. That can either be done with your attorney or you can do it by yourself. There are a lot of websites that can help you do that. The thing is they're not meant to be explained at the level that we can understand. It's just saying, this is what you need to do and this is what you need to file. A lot of times people miss out on the important information as far as when it comes to visits, wanting debt settled, and making sure that their assets are protected. Now, let's say everything's fine, you file a petition, you and your soon-to-be ex are in a complete agreement. It can be done as quickly as 60 days, provided that everything is completed, meaning if you're a parent, you've completed the requisite classes, you've turned in the certificates, and everything is fine and dandy. But life doesn't always work out like that.
Usually not. Okay, Gaby. So, do I have to have a reason to divorce my partner?
Absolutely not. So in Texas, we do allow for no-fault divorces, meaning you don't need to have a finding of cruelty, adultery, any of those findings. Now, let's say you really are upset with them and they did you dirty. You can go down that route, but know that it's going to be a lot.
No, I mean, you can, but
it's more expensive and it'll be a lot more time consuming. It'll be better just to get it over with, get what you want, and move on.
So we're separated and she's threatening to leave with the kids or drain my bank account. What can we do?
You can always put in a temporary order. What that means is you're swearing to a judge saying that if this is not acted upon, something bad will happen. Bad in terms of kids may leave the city. Your bank account savings may be drained. And so a judge, based off of that affidavit in motion, can issue a temporary order stopping your soon-to-be ex-partner from squandering your savings or running off with your kiddos.
Hey, all you ladies who want spousal support when a divorce happens, it's really not a thing, except in very limited circumstances. So gentlemen, don't be fooled that you have to pay baby mama her own little allowance when you divorce. In most cases, that's not true.
So it generally happens in a couple of the areas, right? So one of them, you can agree to it. So if you get snookered into agreeing to it, well, guess what? If you sign off on it and you agree to the terms on there, you're stuck with it. But usually in most cases, the court will award it when there's a finding of domestic violence. It could be a final conviction or deferred. So, and the caveat with that is it needs to be either 2 years before the filing or during the divorce proceeding as it's going on. So let's say you and your ex 20 years ago had a blow down, knockout, drag out fight. Well, guess what? It's past the 2 years. And at that point, the court will not be inclined to give you spousal support based off of that. Another issue that they would consider is as far as if the other parent or the other caretaker is responsible for someone with a severe handicap or disability. Let's say at this point, you're not working because your little one is severely ill and you're the primary caretaker for that. They may also be something that they take into consideration, as well as the dynamics of that. So let's say you both are similarly situated, you both are UTEP grads, and both have opportunities for employment. The court's not just going to award you because, you decide not to stay at home and hang out with your puppies all day. There has to be a valid reason for that. And most of the times the court are not inclined to award based off of that.
All our people wanting divorces need to know about assets and debts. How do we divide them up?
So the court applies the standard fair and equitable. So what does that mean? The court determines what's just and fair. So it's always important to CYA when it comes to accumulating those debts and assets, especially when it comes to credit cards.
I know that they have to file for divorce, but what are the next components like service and answer and all that jazz?
And so just with any type of law, the other party who's going to be affected by that, assuming you're soon to be ex, needs to be made aware of that. So that's where service comes into play. So anyone that's seen Pineapple Express with Seth Rogen as a process server, those are the type of people that give you notice of that petition for divorce, child custody, child support. Now, answer. Answer is pretty much your response to your ex's petition, meaning they're wanting to file for divorce. You're not obligated to file an answer, but if there's anything that you're contesting, you want to fight about, it's best to preserve your rights because you're only given a limited amount of days to put that answer. Because let's say your ex files a petition, you don't answer, you don't show up to court. Guess what the court's going to do? Give a default judgment. Judge is going to sign off and say, well, this person really doesn't care. And there may be some good excuses as to why you're not there. Say you're deployed or in another country. But you want to make sure that notice was properly given. So let's say they never gave you that notice. That's a reason to go ahead and contest and reopen those motions. So
an issue that happens sometimes when you've got an open criminal case is your dad or mom and the other party has a protective order against you. Can you still see your kiddos? So I'm going to talk about the criminal context and then Gabby will talk about more of the civil context, but here's the deal. As a judge, I grant temporary protective orders based on victim statements, alleged victim statements, complaint affidavits, things like that, okay? Those are for a period of time. Unless the kiddos are a party to the violence, I usually do not grant the protective order against the kiddos, okay? So you will still be able to see your kids. Now, you can't go often within 200 feet of her house or her in general, but you can have a neutral party exchange the kiddos and you're not in violation of the protective order. Now, if there are other issues that happen, the kids were present, if there's violence against the kiddos, for whatever reason, there's a temporary protective order and those kiddos are named, then you will not be able to see your kids until that order ends. And then whoever is the alleged victim of that protective order, that family violence case, can file for a civil order. And so that's where the civil comes into play.
And so we're talking about civil orders with respect to divorce, and we're talking about domestic violence. These two are not one and the same. So the orders that Alex talked about are coming from criminal events, alleged criminal episodes. These are given by the county attorney, and so you don't necessarily need to be arrested. You don't necessarily need to have the criminal component, but you can just go up to the 5th floor, write an affidavit, giving a statement in support as to why you're requesting it. And so there you can include your kids, you include grandma, grandpa, anyone that's including that household. And so that order is generally a lot more encompassing and it covers a lot more items to take care of. So when that order is originally issued, it's about a 14-day order, give or take. And then you have hearings. So meaning the person that is asking for that order needs to continue going for these orders and requesting for them to be extended. So this is where it's important, where service plays an issue as well. So let's say you're served with that protective order, you're aware it exists, and you're aware that you have an upcoming court date with respect to that protective order. You don't show up. We've seen time and time again where a judge will sign off on a 2-year protective order. You don't want that to happen. Now, when you're thinking about divorces, protective orders come into play when you're thinking about assets, when you're thinking about situations with the kids, where necessarily violence isn't being an issue alleged or being the main focus of the reason why you're asking that. You're wanting to ensure that your ex-partner is not moving off to Austin. You're wanting to make sure they're not finishing off their pension, trying to go through the joint savings, all of those accounts that are going to be looked at into once you file for divorce. So there's a big difference when it comes to that.